Good evening, ladies and gentlemen, and welcome to the Bunker Show. You're joining us this evening. We're coming to you live and direct from our Old Bailey bunker. We've got one of our Adventures in Legalland shows for you. And with me in the bunker this evening, here's Helen.
Good evening, everyone. Really happy to be in the bunker again. It's been a week again already. Hope you really enjoy the show. We've got some good Legalland stuff for you today. And don't forget to join me in the chat room, ask any questions or feedback for the show, and I'll get it on live to our guests.
And also joining us in the bunker today is my wingman. Here's Jimmy.
Hi, good evening, guys. Really looking forward to the show. And yeah, it's just it's always lovely to be here, man. It's great to see you all again.
And also with us today is Vin James, our regular Legalland expert. Hi, Vin.
Hello all. Thanks for having me back on the show again. Great to be back again.
And thanks for joining us, Vin. And also will be joining us today is Peter Gilbert, who's had experience as a litigant in person and more recently as a Mackenzie friend. So good evening, Peter.
Hi, hello everyone. It's good to be here.
Thank you ever so much for joining us. 2 weeks ago, we had David Henke as a guest, and we covered quite a few bits of the recent Westminster investigations.
Yeah, and I think the timing of that show was pretty appropriate, actually, because, considering what's going on with Ken Clark and Ben Fellows, can you give us a bit of an update, Fabrice, on that situation?
Well, the Fellows-Clark case, Ben Fellows was found not guilty. And since that case, we weren't able to discuss it as the verdict hadn't been reached. But Exaro had pushed, along with some of the other supporters of Ben Fellows from IFN News and Lou Collins. And what they were pushing for was to get disclosure of Ken Clark being reported for assaulting a 14-year-old boy. So that's multiple accounts now.
But am I correct in saying that it's gone a little bit cold and quiet in the mainstream media on that front?
Well, it does seem that there's also been a couple of other revelations in the Westminster investigations that have seemingly taken up a chunk of the headlines, and also the passing of Cilla Black. And it seems that with Ken Clark, it doesn't seem for somebody who was Minister of Justice. He's also, for many years, was on the steering committee of the Bilderberg Committee, he replaced Lord Carrington and Henry Kissinger. So a very powerful role there. And as Ben Fellows reported, that the police said that Ken Clark is above the law. So when you have reports like that, I feel it's essential for the public to do their part.
Well, when you think about it, the predominant story at the moment seems to be the Ted Heath story. And, on the face of it, Ted Heath would appear to be a much bigger fish than, say, Ken Clark. But from what you're saying, actually Ken Clark does have his role.
Well, the difference is, of course, is Ken Clark is very much alive, and Ted Heath passed away in 1995, I think. So that makes a considerable difference in terms of how any investigation can be put forward, and the amount of people who are potentially affected by it. The interesting thing with Ted Heath is that it shows that for somebody with as many reports against him as there are now, that for him to be in that senior position, and the people who are supposed to ensure all the Crown authorities, all the judiciary, all the civil service, and the intelligence agencies, to not be aware of the gravity of the Ted Heath situation.
Yeah, and furthermore, with the Ted Heath situation, it's been announced that the Wiltshire Constabulary will be investigating the claims against him. And weren't the Wiltshire Constabulary involved in the Jersey investigation in the Haute de la Grande?
Wiltshire Police took the lead in that investigation. There was a police commissioner who was from Jersey, who was very seriously undermined by that investigation. And of course, a bit like the Waterhouse inquiry that was looking into the Bryn Allen care home, children's home, and the ring surrounding that in Wales, the Waterhouse inquiry wasn't an effective inquiry, and we know that now. And it seems that the Wiltshire inquiry into Jersey previously, so for 10 different police forces now to all be under the same umbrella of Wiltshire Police. And again, that inquiry, does it really have the teeth that it needs to look behind not just Ted Heath, but the people who facilitated him to become leader of the Conservative Party and Prime Minister? And
of course, other notorious cases of child abuse, systematic child abuse, like, say, Kincora.
Well, the interesting thing with Kincora is we have an overarching child abuse inquiry, which hopefully will look into Edward Heath. Justice Lowell Goddard has recently initiated the next phase of that. But there are separate inquiries into Northern Ireland and Scotland, and so whether those inquiries will be able to get to the bottom of the trafficking of children and young adults from Northern Ireland across to Britain and potentially into Europe as well, as it now seems. With separate inquiries, I think with the legal system, it's up to the public to show their confidence or lack of it in any inquiry, which was how come we got the overarching inquiry in the first place. So with Edward Heath and with the Kincora, I think it's worth seeing if those inquiries meet the standards that we would expect for such a serious matter.
Yeah. I actually think it's really come time for, just say like a police station crime map. It's time to start putting dots and flags and connecting those dots and flags, because they're becoming more obvious and they're coming more frequently. So it's really come time, hasn't it? Especially
as Leon Britton as well. His question, the files that he had. So it has become to be very much in need of the public keeping attention at this point, and pursuing the justice that they need, which was shown how effective it was with the number of people who complained about Greville Janner. Yeah, and I do believe at this point that we are getting well beyond David Cameron's conspiracy theorist point that he made at the UN, and going on from that point, maybe we should talk about Chris Spivey's situation. Well, just to finish with Greville Janner, I think he was in court last week. I think he's due in court again this Friday. Of course, when I say he's due in court, actually his counsel is there, and they're trying everything to make sure that he doesn't attend. And really, he should attend, even if it's just to show his face, to say, I'm too ill to attend. And that's something which, as we mentioned with Ken Clark, it's important that everybody faces the same fair system of justice. Well, you were saying last night, how many decisions has he made at the House of Lords since he has claimed that this dementia? He's made 203 votes. So if he's able to vote on legislation to approve it or deny it 203 times, then really it would kind of follow that he should be a party to that legislation. But I mean, as we will be going through this show, we have a few questions for the way the justice system is moving on. And as you mentioned, Chris Spivey, who was who was found guilty without being able to cross-examine witnesses, even though 2,000 plus people have signed a petition to show that there obviously is public interest. And the way the mainstream media has attempted to portray Chris Spivey is quite similar to some of the dirty tricks that they're reserving for the people like Abu Hamza, the hooked hate preacher.
Well, I mean, for anybody who isn't familiar with Chris Spivey's work, could you just give us a quick nutshell of like his approach and what he does?
Well, Chris has his own unique style in terms of the directness of his writing. It's very humorous in a lot of ways, but it's also very inquiring. He is meticulous with his facts and information, and he presents that. And actually, his website gets a phenomenal number of hits. It's ranked just over 200,000 in the world, about 10,000 in Britain, which is considerably more than most other journalists get, because he commentates on media propaganda. He also deals with very serious sexual abuse. He deals with false flags, and he also deals with the judicial system.
It was one of those false flags that was involved in this case, wasn't it?
Yes, he was allegedly harassing two members of the Rigby family, which constituted a total of 2 charges relating to each person. And that was what constituted the harassment, was an article on his website and one inquiry to see if they would like to be interviewed. And if that's harassment, then I'm going to be guilty of it a number of times when just sending people a polite message to ask to be interviewed.
Yeah, I mean, that approach really shuts down debate, doesn't it? Really quick. But, what I found really strange about the Chris Spivey case was that, the Rigby family didn't even show up. You think the nature of the case would have demanded their presence?
And also, Chris is right to cross-examine them to see if they actually were harassed, because the information, the article, was up on his website literally until the day he was sentenced, and had been up there 14 months previously to the complaint. And of course, he's never. You have to go and look for his website. You have to go and click on it. So if you don't want to see somebody's reports, then don't click on the website. That doesn't sound like it constitutes harassment. But what did happen was the Crown Prosecution Service brought in a very senior lawyer who's actually at the rank of a recorder, which is actually more senior than the district judge who is hearing the case. And to not allow cross-examination of witnesses is a very, very serious breach. And of course, with 2,000 plus people signing a petition, it's obviously clearly in the public interest for people to know and see that justice has been done. The issue is that it seems as if Chris has been steamrolled. It's almost as if the verdict was in place. The reason I feel that they may be doing that is because to deny Chris his human rights, his right to a fair trial, his right to a family life, under Articles 6, 8 and 10 of the European Convention on Human Rights, which is enshrined in the Human Rights Act, which is something that our present government is very, very keen to take out the legislative process. So
you reckon that David Cameron and co are trying to frame Chris as some sort of boogeyman, some sort of poster boy for the bad boys?
If they can frame Chris as a reactionary and extremist, as somebody who's unpatriotic, then if they can't, if they can then in the mainstream media frame it that he wins his appeal using the Human Rights Act, that could give them leverage to badmouth the Human Rights Act. whilst obviously addressing the travesty of justice, which has gone on, where you can be convicted of harassing somebody, but actually your lawyer can't even cross-examine their competence, credibility, and the veracity of their statements.
Do you think the current sort of government narrative is actually clamping down on the media? I mean, do you think this is where it's all kind of like headed?
In terms of Chris Spivey and painting pictures for the media, I think that I think that's a consideration, because to be able to leverage the courts in the way that the CPS and the system has been doing, with the media following on trying to lay down that kind of narrative, then it would play for the media as Abu Hamza has now been deported and is off with his intelligence agency mates or whatever he's doing. They could be clearly in need of divisive bogeymen. And the tragic thing is, as we'll discuss, from now on in the show, that going to court is a very stressful thing. Having people interrupt your life, your work. A lot of the fine journalism and research that Chris had been doing, he hasn't been able to do because he's had to have legal matters. And it's very, very, very stressful when they may affect your livelihood. They may even attempt to put you in jail, as these are some of the extreme stresses on that way. So that can kind of show some of the establishment's reasons for attempting to railroad Chris and keep him busy for the best part of a year if it goes to appeal process, because the legal system does move very slowly. And if Chris's judgment is overturned through an appeal, it can be framed in that way.
Just quickly, how can we out there show Chris our support?
Well, number one is sign his petition. He's also being sentenced on the 27th of this month, I believe, and that's in Chelmsford Magistrates Court. The more people that are there, whether you're outside, whether you can have access to the courtroom and show your support and just make your presence felt, that really does help and make a difference in that way. But there is a petition that can be signed, which states that it's one of the oldest established tenets in British justice to be able to cross-examine and confront your accuser.
Yeah, I guess it's just showing the establishment mafia that they've been clocked on this one.
Yeah, and the other thing is having a really senior Crown prosecutor who is a QC and works as a recorder, which is a more senior judge than the district judge who's hearing the case, and a very junior legal aid barrister that I think Chris has been able to get working on his behalf, doesn't seem like a very balanced equality of arms.
No, it's straight straight out of Chris's own satirical kind of way of thinking, isn't it? It's bizarre.
Yeah, that is very bizarre, especially as there are legal aid cuts at the moment which are cutting the Crown Prosecution Service to the bone, and there's also been some strikes and some magistrates quitting the bench due to the changes in the legal aid system. Vin, I'd like to see what your thoughts are on Chris Spivey not being able to call his witnesses.
Yeah, I mean, it's just a totally rigged game, and it's as if they they can't even be bothered to make it look good anymore. That's the thing, isn't it? I mean, like you say, it's one of the oldest established principles, if you like, in British court history. In fact, just about most courts around the world that run under an adversarial system, and to be able to cross-examine your witnesses is one of the most absolute rights you supposedly have under due process. And it just goes to show how rigged the game is now, and just how corrupt. Well, we know how corrupt they are, but now it's not even a matter of when it comes to cases like this, where obviously the establishment is being threatened. They will just ignore every principle going, in terms of being, ensuring that you're going to get convicted no matter what, and to hell with the consequences and a few, a bit of bad public relations. I think they're prepared to put up with that just to see that they can, get a conviction against someone. It's absolutely disgusting. And these people don't seem to have a conscience about it either. That's the thing.
Well, it's not just the conscience, Vin. I think in some ways it's also that if a judge makes a railroaded decision, makes a bad decision, the penalty for that is just a piece of paperwork. So the fact that they have immunity for any miscarriages of justice that they have, or at least that's how it appears.
Yeah, that's it. But it depends on what the thing is. Even if he puts an appeal through, they'll lock him up, very likely, make it extremely difficult for him to try and get the transcripts. And by the time he actually puts an appeal through, well, his sentence might be up by then anyway, depending on what sentence that they're going to plan on wanting to give him. So these are the games they play. It just goes to show that they won't let themselves be held accountable, and that's why we've been saying all along. The entire legal system itself is based is founded on a completely flawed methodology. And the reason is because the only people they're accountable to is themselves, and if they don't want to hold themselves accountable or hold themselves up accountable to anyone else, there's not an awful lot we can do about it. And what sort of legal system, what sort of justice, system of justice is that? It's ridiculous.
Yeah, I mean, this is why I think we have these Legalland shows here in the bunker beneath the Royal Courts of Justice, is because it seems that, as you stated, if they don't hold themselves to account, then what we can do as the member of public is show that their public relations, their facade of a fair hearing, being able to confront your accuser, being able to see the facts and merits of whatever charge you have. Where that doesn't work, if people question that, if people raise that, then that affects the credibility of the judicial system, which of course with the legal aid cuts we're starting to see some of the effects of that come through now, because not only are people obviously not being able to get access, especially in family matters, to get legal representation if they choose to, but also a number of magistrates have decided to quit. I think it's over 30 now, and in terms of that, it's also the fixed court charges.
They're just trying to make it more and more difficult for us to actually be able to even challenge them. And
I have a question here from the chat room about legal aid, withdrawal of legal aid. It says, I have a case against a local council for abuse by a teacher who was found guilty in court and received 3.5 years in prison. I was approached by a solicitor who wanted to take it on with a no-win, no-fee basis. The council admitted responsibility as a duty of care and paid out to the other victims, but they're not responding to my claim, even though being pressured by the solicitor. What I didn't realise is that if it goes to court again and I don't win, I have to pay for the expenses for psychiatric reports, fees in general. Question is, do you think that withdrawing legal aid was meant to stop us making claims? Sorry if it's a bit long.
I'd say so. Yeah, it's bang on the money in that respect.
Yeah, it definitely doesn't. I don't think people were inclined to use legal aid for vexatious litigation or frivolous claims, and of course there were checks in for legal aid when people wished to access it. The other thing is, actually, I don't think that there was any danger of legal aid being overused beforehand and being a waste, because people definitely noticing now it's being withdrawn. So it does make it much.
Sorry, yeah. I mean, it actually wasn't that easy to get even before then. You basically had to be, either on dole money in a council house with kids, black, gay, one of those ethnic groups, in order to basically get them. I mean that in a derogatory way, but you basically had to be in a far worse situation than say just someone who's working class and still hasn't got two halfpennies to rub together, But as far as they took it, well, if you've got an income coming in, even if it's only £100 or £150 a week, you can afford it, so you don't qualify. So even when legal aid was more readily available, it was still notoriously difficult to get, I found. So
yeah, that definitely is did seem the case. In terms of things like reports and I'm not exactly sure the other thing that was mentioned in the question, but do you think there'll be fee remission available for those type of things?
Supposedly they are meant to make that available to us now, but I've been looking into this myself, and it does seem as though they are starting to withdraw certain remissions and that they used to offer before, especially trying to get transcripts and things like that. They're making transcripts notoriously difficult to get hold of. I mean, one particular case I was on a few years ago, they wanted to charge us, I believe it was well over £1,000 for the transcripts. That was a 2-day trial. But yeah, they wanted about 1,000 to 1,500 quid. They wanted us to pay it up, even though the couple that I was helping obviously never had that money.
That's a big intimidation for the average punter, isn't it?
Sorry?
That's a huge intimidation for the average punter, isn't it?
That's right, yeah. Because one way or another, they get their money, and that's what people begrudge having to do, especially in my position, where you've won, you've beat the buggers, but you want the transcripts, but then they basically want the equivalent to a fine anyway out of you just to get the transcripts. And supposedly if these courts are meant to be public and open, or at least open to the public, they should be freely available. After all, these courts are supposedly paid with out of our taxes anyway, so why should we have to keep paying them more and more money for stuff that is already prepaid for by us anyway?
It doesn't make sense. And also, for fee remission, that is being able to claim your money back for the costs that you incur for things like reports. Again, that waste, that takes a lot of time applying for it and waiting for it to come back. And it's also, again, quite hard to find information about that sort of way in which you can make it just that little bit easier.
There has been a lot. Well, I don't know if you've noticed this, but I've noticed that there have been a lot of websites and information that used to be more readily available even 5 years ago that has now sort of disappeared. You can't go digging for a lot of stuff now. I mean, there was a lot of case law that I found, about 5 years ago now. I went back to try and find some of it again. It's completely gone now off the internet. Can't find it.
It's one of those things when you do look into. I'd like to talk a little bit about being a litigant in person and some of the experience that a few of the people have had with doing that, and the challenges. And being a litigant in person is when you don't have legal aid and you don't have a solicitor representing yourself. So being able to find resources to help people do that, and sometimes you get lots of conflicting information. So, Vin, what do you think the pros and cons are of being a litigant in person?
There's plenty of cons, as we know. The pros are that you're not basically giving your money over to the same people who were basically dragging you there in the first place. In the sense of, not using a lawyer. The only time when a lawyer could be useful in that respect is to use them as an advisor, but not obviously a representative for you. And this is what they won't offer. That's the thing. But the thing is obviously, if you're representing yourself, you can ask questions that a solicitor wouldn't dare ask in court themselves, such as the questions we ask through the Socratic method is just asking a simple question like, what facts has the court got to prove that it has jurisdiction from the prosecution? Obviously, issues regarding the applicability of the law. You can ask issues regarding there being an obvious and clear conflict of interest. That's always the case whenever you go into court. These sorts of questions, no solicitor would ever ask. So that is the advantage of being able to represent yourself, because you don't have, or you shouldn't at least have, the fear of asking straightforward, honest questions like that. The problem is, obviously, they don't like questions like that because it undermines their entire authority and basis for doing what they're doing. But I think we need more people actually challenging them on that, in that sense. Obviously, the cons are. Sorry, go on.
I was just going to say, do you think that they use semantics as a weapon in the courtroom?
Oh yeah, because it's arguing. I mean, if you pick up any legal book and they talk about what you have to do in court, it's all about arguing, and it's arguing in the sense of who can put across the best sounding story, irrespective of whether it's got any merit to it, any facts in there or not. It's just a matter of who sounds the best, and that's how you can win or lose a case on. And that's completely the wrong way the court is supposedly meant to work, or at least a fair hearing is meant to work. It's meant to be based on the facts and the facts alone, and it shouldn't be a matter of who puts them across best, so long as someone just puts them across and lays them on the table. It shouldn't matter how eloquently or how well presented you do it, but you are up against people who will argue semantics, and you're up against sophistry and everything.
So I mean, I know that you've been a litigant in person, Vin, and also a Mackenzie friend. Peter, you also have done a good bit of. You've gained quite a bit of experience over the past couple of years. What have you found to be the most challenging thing about being a litigant in person and supporting people there, Peter?
Well, it's the intimidation of the court. But going back to what Vin was saying, that when you got legal representation, or if you're lucky enough to get it, they're tying all the loose ends up, so there's no appealable points. I mean, that's their job. Whereas I believe when you're a litigant in person, you're actually laying a foundation for an abusive process or due process failures by the judiciary. So you can actually challenge them at a later date, because 9 times out of 10, I believe, that you're going to get railroaded. They're going to find against you, and therefore the questions what are asked, I believe, is just laying the foundation for a later date to appeal to a higher court.
And that can be quite an effective way if you can stick to your guns and make sure that an abusive process is when you're asking some of the questions that Vin mentioned earlier about jurisdiction and evidence of a complaining party is another one, applicability of the law, and the factual basis behind it. And if that hasn't been presented during the trial and you can show that, and yet a sentence is still passed, then effectively the process is being abused because you haven't been presented with that evidence. and you haven't been given the opportunity to challenge it. So,
Sorry, go on.
No, carry on, Vin.
I was going to say, because due process isn't people seem to look at due process as a process of simply getting you convicted or putting you through a trial. It's not that. A due process is simply all the safeguards that are meant to be in place to ensure that you get a fair hearing, and that's what we mean by due process, being due fairness at each and every stage, and that's what they've got to be vigilant of, at every point in the trial. So that's what due process basically means. So when you're not getting due process, and it carries over into this thing that we call an abusive process, then that's what it means. It's an abuse of them, supposedly keeping the checks and balances of the fairness of that trial and seeing that the truth is being got to, and it isn't being buried under sophistry and fallacies and everything else. And the thing is with being a litigant in person is the fact that when you go in there and you use a solicitor, say, the solicitor is already of that opinion that court has jurisdiction. He'll never challenge it. He believes that the law applies to you. He'll never challenge it. So he goes in there with a completely different mindset because he believes he already has preconceptions about the entire validity or alleged validity and legitimacy of what you're walking into. Whereas obviously when you're a litigant in person, you can go in there and you can question absolutely everything. There's nothing off the table. There are no sacred cows. Whereas what a solicitor will have, he'll go in there with all that baggage of the sacred cows that, he believes that this system is fair and just, and if only you argue well enough, it's a free horse race as far as they're concerned. And I've even had this from judges myself where they say, I believe Peter was at a hearing a few years ago where a judge said this. It might swing either way. The jury might decide to take your side and feel compassionate or whatever, and they might take your side of the story. And it was an issue of saying, well, all you're saying then is that it's just a three horse race or a two horse race. Even it's just a matter of who are they going to believe based on who puts the best story across. It's got nothing to do with the facts, nothing to do with the truth. It's all basically, it's an appeal to emotion. If you get on their good side and you get them liking you, they might find you innocent, and that's completely, and that's a complete perversion of logic.
That's a really important one as well. Is that we, try and keep our emotions out of it as much as possible and stay rational. But I just wanted to again draw attention to this abusive process thing because, I came across it first, already into my case. I hadn't actually known about the calling an abusive process beforehand. And actually, it's obviously not used very much because nobody in that room really knew how to do an abusive process, and they messed it all up big style to begin with because they weren't sure of their own procedures. But it's really important that people are aware that they can at any point call it on due process hasn't been met, and there is an abuse of the process, and that's often how we hold them to account.
That's right, because normally, as we all know, the presumption of innocence is never there. Despite what they say, it's never there. And I think my recent hearing that Fabrice and Peter came along to with me, that was self-evident. You could tell that judge had already predetermined, the law applied, and because I admitted to being a driver of a car, that made me a speeder, that made me guilty, and I had to somehow show I wasn't. I somehow had to, and I had to prove my innocence on that one. And that was as plain as day to see. And I think the judge realised himself afterwards, once I started pointing out it was actually a fallacy, he actually became a little embarrassed about that. But he still kept on committing the same fallacy regardless, as you know. You was there and you saw it.
Yeah, and he sped through right to the end as quickly as he could from that moment onwards, I think. He's okay, well, you're probably going to appeal this, so I'll just tie this up as quickly as possible and get off and see if I can get a few rounds of golf in before evening. Another interesting thing is because prior to going to court, people ask for full disclosure of the evidence, and if you're asking for evidence of the applicability of the law or evidence of a complaining party who has standing to complain against you, i.e. somebody who suffered a loss, an injury or harm. When you're asking those questions, so that you can understand how you can whether what you're guilty of, or whether you're guilty or not guilty of any crime, which is making a plea. So being able to enter a knowing plea, i.e. understanding the cause and nature of what you've done, and how the law applies to you, and who you've committed the crime against. You need to know that before you can make a plea. Sometimes we found that they say the Crown Prosecution Service hasn't generated a file, so the magistrate enters a plea of not guilty on your behalf. And now, previously, the matter of cost didn't come up till the end of a trial. But now, if with the new criminal court charges, you can be due for over £150 worth of cost just by the case going to trial. So if you're forced to go to trial or begin the trial process because the magistrate has pleaded on your behalf, then wouldn't the magistrate be liable for that responsibility if you're saying you don't have enough information to plead? Now, I know 38 magistrates, I think, have quit due to the criminal court charges and the changes to the legal aid system. So it could be that some of the magistrates are being put in that position. I don't know how you think that affects litigants in person being pushed to trial, Vin.
Yeah, I mean, it puts undue pressure on them. It's going to put them in a situation where they feel, well, if I dared... You're sort of being told up front that if you dare challenge us, here's what you can expect. And now they've made it a set fee. So basically what they're doing is they're putting you in a situation where it's coercion. It's still, they're still trying to force you to take a route that suits them. So the thing is about giving a plea. It's a form of what do they call it? When you're doing a deal with them, like if you plead guilty now, where we'll only give you like half the sentence or something like that, And they're trying to make a deal with you because, and what that shows is the weakness in their system, because it goes to show that if they were actually confident and actually had the evidence to back up the claim they're making against you, and actually had the evidence and the facts to put on the table there and then, they wouldn't have to use such tactics. It would just simply be a matter of, right, we've got you in court. You can either plead guilty. Other than that, you're assumed innocent anyway. Yeah. And if you want us to go to court and have the other side prove their claim, then fine, we'll hear it. But the fact that the judge is supposedly meant to be impartial, but then they put you in that situation, just totally debunks their entire premise.
Well, no, it's not just the fact that if you plead responsible, you can get a reduction in your penalty. It's now that if you don't do that, you could have a penalty if there's something unforeseen, or if you don't make your case. So in terms of what you're saying, that's definitely an added threat, especially if they're not doing their system or their procedure, which kind of leads us on.
I was just going to say, because another thing is, and maybe it's the answer to the interim between the trial and that plea hearing, is to have a case management hearing, and that maybe they can't put a charge on that. And I wanted to ask you, Peter, because you've had some success around the case management stuff with some forms that Bradley Knight uncovered, haven't you?
Oh, yeah, the effective case management form.
Yeah, that one. Could you tell us a little bit about that?
Well, if you Google it, it's the first one that pops up, the effective case management form. And how
have you used it, Peter?
Well, I took it into court for my son, who wasn't there. I got the information off of Bradley Knight. He guided me in what to do, which was very good of him. He definitely knows what he's talking about. And
it's helpful to have people, have a look over the paperwork in that respect.
Well,
how difficult did you find it, filling out the form?
Well, I thought I filled it out okay, but even if you don't fill it out okay, they're going to let you know. They're going to say, well, this is wrong, so then you just amend it. So I don't think you can go too far wrong with it. And also, you can ask for unused material.
Exculpatory evidence.
Yeah, that's it.
As well as getting full unused. As well as getting full disclosure for the evidence that they are actually going to use. Exculpatory evidence is other evidence that they've uncovered that they're not necessarily using. So sometimes can be very positive to your case. Yes,
and I handed it in to the usher to give to the prosecutor, and they dropped the charges against my son, which was I was amazed, because normally they just maybe adjourn it for the prosecution to get their case in order, or they make a plea for you,
or they put it to another date and rev up the steamroller.
Yeah, exactly. But
the thing with the case management form, it appears, and part of the case management hearing process, is that's supposed to be the check to make sure that you're being treated fairly and that everybody is doing what they're supposed to be doing in terms of making the case progress. And if there is a backlog where they haven't been following their own procedures, then getting them to put it down on the case management form will kind of show it up, which is often what leads to them withdrawing the charges.
Yes, but they're supposed to fill that form in every time, and they don't, which is pretty amazing. They're actually, every case that is presented before the court, apparently...
Yeah, so, Peter, if I've got this right, they're expected to... it's a requirement according to their own rules that those forms are filled in, and yet no one ever sees one, and so far, unless you brought them up or other people have brought them into court. Is that right? Really, they should have one filled in before they come to court?
Well, yeah, they should, yeah. I mean, the prosecutor should have one filled in, really, but obviously they're lazy, or the CPS. Like, they just don't... Well, I don't know how they get...
It could be the funding that we mentioned earlier with the legal aid cuts, is that they just don't have the people who are there to be able to follow through with their actual process. So, Peter, have you found court to be a kind of intimidating place? I mean, because I know that you found that with practice, you found it easier to go into that environment over time.
Well, I still find it intimidating. I mean, I have been in court on a number of occasions, and every time you go in, I know what they can do to you. They can, they've got violence. The backup, that is the violence.
So and underneath all that paperwork, there's a jailer's key, and they can throw you in a cage if they really, really want to, and that can be quite intimidating, even if it's just in the back of your head. I think Jimmy's got a point.
Yeah. Hi, Peter. Jimmy here. When Fabrice introduced you, he mentioned that you've appeared in court as Mackenzie friend. Could you just explain for our listeners your role as Mackenzie friend?
Well, a Mackenzie friend, I believe he can go in and assist the person being charged. He's not allowed to speak, or in some cases, if a Mackenzie friend makes representations to the court, he might get a right of audience, but normally they don't entertain it. And a Mackenzie friend can obviously give advice, but that slows the process down in the court.
Which can sometimes be quite a useful thing if they're attempting to steamroller you, because it can give you a moment to collect your thoughts and talk to somebody who can give you support and is obviously familiar with your case.
Yes, that's right. Yeah, you can actually slow it down to your pace that you're comfortable with, which is pretty cool, I suppose.
Well, that is pretty cool because, you know, even though on paper you don't really have any power, you do actually have a little bit of leeway there. Would you agree?
Yeah, well, yeah, I suppose you do. I mean, I'm pretty new to this. Yeah, but I agree with you there. Yeah.
Yeah, because I guess by asking some of those questions, I mean, Vin, you've worked as a Mackenzie friend. Is there anything you'd like to add about how useful that can be, and having people supporting you in the public galleries?
Yeah, it just gives you that confidence. You don't feel like you're alone, especially if something gets said by the judges or even a prosecution that's so outrageous that, you know, you're just glad other people were there to hear it, you know, and confirm it. You know, and it does give you that confidence. I mean, when you two was there with me the other week in court, it really did help me because I hadn't got a lot of practice in myself before I actually going to court because of work commitments and everything else. But we was able to sit down and have a chat, a long chat for a good few hours because, I mean, they kept us going till I think it was about 2:00 in the afternoon. We finally got our case heard, and what happened was, you know, it was meant to start at 10:00. So we had all that time when we went to lunch and everything, didn't we? And we could sit there, have a talk, and it really did help me get my head more in the game. There were still things I made cock-ups on and mistakes, but, you know, I think that we all do that every case. You know, you come out thinking, God, I wish I'd said that, you know, or I wish I'd reacted to that a bit faster. But, you know, it really does help. It's more a confidence booster than anything, and it's the fact that because you've got someone there with you that you've talked about this stuff for a long time with, it can just help trigger little reminders in your head, you know, things like that.
Which is the great thing about the role play groups that I know you're very actively involved in. And that's through markstevens.net. You've been co-hosting the brilliant No State project with Mark a few times a month. So that's a great resource for people to check out. My YouTube channel links to some of your videos and some of the No State role plays. There's also a YouTube channel called No Comply, which has some great little psychological coaching, which is really, really useful for people when they do go into court. Are there any other resources that you can point people in the direction of, Vin?
Just what we always say regarding logical fallacies and that. There's a really good book written by a bloke called Bo Bennett. I think you can get it on the internet for a couple of quid. It's called 300 or logically fallacious 300 logical fallacies or whatever it's called. It's that's a really good book to get your head around. But there's plenty of free websites on the subject, listing most of them. Sorry.
And of course, Adventures in Legalland by Mark Stevens, which is a really fantastic resource, which I can't recommend highly enough.
So yeah, we do have a wiki page as well. I think it's called Adventures in Legalland Wiki, which if you join as a member, you can actually add material to, which is something I've been promising to do for a long time, and I will get round to it eventually, and we'll start adding some more case law in there and that. And the other thing is with Mark Stevens, we do actually have what's called an application to dismiss, which is essentially what's known in this country now as a submission of no case to answer.
Okay, well, we're running right up to the buffer, so we'll
okay. I'll just get this out quickly. So, all right, yeah. So
next time, thanks ever so much, Vin.
Okay, that's great. Thanks ever so much, mate, for having me on.
It's a real pleasure as always. Thank you ever so much, Peter, for joining us in the bunker. I really appreciate your input.
Thanks very much indeed. Thank you.
Yeah, thanks for being here, guys. Really enjoyed the show. Really enjoyed the chat room. Thanks for so much good chat in there. And thanks for listening.
And of course, with us, thank you ever so much, Jimmy, for being with us in the bunker.
Always another illuminating night in the bunker. Thank you, guys, and see you next week.
And don't forget that coming right after the bunker show is the Dark City Cannabis Compassion Club with Martin, Sarah and Bob. They've got Alan Buffrey, who's a really interesting guy. He's travelled to over 30 countries and met all kinds of communities and people. And he's got a really interesting book called All About My Hat. So that would be worth hanging on and staying tuned for. And if you're still going at 9 o'clock, Native American Secrets with Shane Sabel is Who's on the Captain Max Steel show. So that seems like it'll be an interesting show. Next week, we'll be back in the Westminster bunker. We hope you'll be joining us too. And thank you very much for joining us on our Adventures in Legal Land Bunker show. We look forward to seeing you next week.